Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to Our Curious Amalgam. I'm Jaclyn Phillips, and today's episode is Throwing the Book at Orange Book Listings, the FTC's views on the antitrust implications of listing patents in the Orange Book. The Federal Trade Commission issues policy statements to let the public know how the agency intends to apply competition and consumer protection laws. In 2022, the FTC issued its policy statement expressing its interpretation of the scope of Section 5 of the FTC Act, which governs unfair methods of competition. Building on that policy statement, in September 2023, the FTC issued another one, this time discussing the specific issue of whether patents improperly listed in the Orange Book can constitute a Section 5 violation or otherwise be anti-competitive. They also discussed what actions the FTC intended to take as a result. Since then, we've seen the FTC take various steps in support of the pronouncements in the policy statement. As we'll hear on today's episode, listing patents in the Orange Book is an important aspect of the Hatch-Waxman Act framework, setting forth the procedure for patent litigation between brand and generic pharmaceutical manufacturers. So understanding the FTC's position, the uncertainties resulting from that position, and what to expect looking ahead are key pieces of the puzzle. And it's time to dig into all of that. I'm here with my co-host, Jeny Maier. Hey, Jeny.
Hey, Jaclyn. Glad to be here.
Can you introduce our guest today?
Absolutely. I'm very excited. Today we have on the show with us Mika Ikeda. She is Senior Counsel for Competition Law at Johnson & Johnson. Mika began her career in private practice and then spent over 9 years at the FTC in various roles, including as counsel to the director of the Bureau of Competition and as Deputy Assistant Director of the Mergers II Division. She joined J&J in 2022, and in her role, she provides cross-sector legal advice supporting the global antitrust review of J&J's acquisitions and divestitures, as well as general antitrust counseling and training and competition law policy. Welcome, Mika.
Hi there. Thanks for having me.
Just as Jaclyn said, we have a lot to dig into with the FTC's recent actions here, but to level set where we are going, want to make sure that we know where we're starting from. Could you help us and all of our listeners understand what's the background here? What is the Orange Book and what's the purpose of it?
Absolutely. So the Orange Book is the common name for a publication that was put out by the U.S. Food and Drug Administration, or FDA, that was originally called the Approved Drug Products with Therapeutic Equivalence Evaluations. Thank God nobody uses that official name because this podcast could go on for hours. It got that nickname Orange Book because of the color of the cover of the book when it was first published back in 1980. It was actually published on October 31st, which is a holiday in the U.S. called Halloween, and that's a holiday that's typically associated with the color orange. So the Orange Book identifies drug products that have been approved by the FDA on the basis of safety and effectiveness. In addition to identifying the drug products themselves, the Orange Book also lists certain patent and exclusivity information related to those drug products. And there are certain rules laying out the criteria for listing patents in the Orange Book. And those are governed by a statutory framework called the Hatch-Waxman Act, as well as other FDA regulations.
So as a practical matter, what does it mean for a drug to be, or a patent for a drug to be listed in the Orange Book? What does that mean for generic pharmaceutical manufacturers?
The Orange Book patent list essentially provides a mechanism for identifying and resolving patent disputes between brand drug manufacturers and would-be generics. So by requiring brand drug manufacturers to list patents that cover their approved products, the Orange Book puts generic companies on notice of the types of patents that a brand company believes cover its drug product and may be willing to defend if necessary. So in the United States, when a drug company wants to market a generic version of a brand drug that has patents listed in the Orange Book, the generic company needs to provide a certification with respect to each patent listed in the Orange Book. We call this a paragraph 4 certification. And in that certification, the generic company states its view that the brand company, the patent of the brand company is either invalid or will not be infringed by the manufacturer, use, or sale of the new drug that's being submitted for approval. Once the generic makes the paragraph 4 certification, this generally gives the brand company the immediate right to sue for patent infringement. And that generally results in an automatic 30-month stay of any FDA approval of the generic company's drug application. That stay of FDA approval remains in place until the patent litigation is resolved or the 30-month period expires. There are some circumstances where the stay can be longer than 30 months, but the general flow is brand drug manufacturer lists its patents in the Orange Book, the generic company files a paragraph 4 certification that the patents are invalid or not infringed, and then the brand manufacturer sues for infringement, thus triggering that 30-month stay. If a brand drug company wants to avail itself of that right to assert its patents and obtain a 30-month stay of the FDA approval while the patent issues are being litigated, it's important to ensure that the appropriate patents are listed in the Orange Book.
Okay. So as we talked about at the outset, the FTC took some actions earlier over the last couple of months about the Orange Book listings and practices that companies have engaged in over time. So starting with the September 2023 policy statement, can you tell us what exactly the FTC announced when it made that policy statement?
Yeah, so in September 2023, the FTC issued a policy statement on, quote, brand pharmaceutical manufacturers' improper listing of patents in the FDA's Orange Book. And the statement itself was pretty short. It was only 6 pages. And it basically said 3 things. First, the FTC said, we think the laws are very clear about which patents should be listed in the Orange Book. They should be patents that either claim the drug itself or a method of using the drug for which approval is being sought. Second, the FTC said it's the responsibility of each drug manufacturer to ensure that the patents that they list in the Orange Book are consistent with those listing requirements. And finally, the FTC said if drug manufacturers improperly list patents in the Orange Book, that can harm competition and innovation for pharmaceutical products and increase costs to patients. And so we, the FTC, will not hesitate to take action against those manufacturers who improperly list their patents. And so what the FTC seems to be worried about is really the impact of that automatic 30-month stay of FDA approval of a competitor drug product. The FTC's concern is that by improper listing these patents, drug manufacturers may be gaming the system and using that 30-month stay to delay entry of cheaper alternatives.
So the FTC, in issuing the policy statement, wasn't taking specific enforcement action. From your perspective, what was the purpose of the policy statement?
Yeah, that's right. I think the FTC was definitely not taking an enforcement action in that September 23 policy statement. There were no specific companies named by the FTC, and they weren't really specifying any particular types of patents that they were worried about being improperly listed in the Orange Book. The policy statement was really just a statement of the FTC's general concern that they think there's some funny business going on with these Orange Book listings and that they intend to look into this further. And they won't hesitate to take action under the U.S. antitrust laws. The FTC said the goal of the policy statement was to put market participants on notice that the FTC intends to scrutinize improper Orange Book listings. And they intend to determine whether those Orange Book listings could constitute unfair methods of competition in violation of Section 5 of the FTC Act, or even unfair or deceptive acts or practices under the FTC Act. No enforcement action in that policy statement, but definitely a signal of potential actions in the future involving Orange Book listings.
Thanks, Mika. And The Orange Book, of course, isn't new. So we're hearing from the FTC their views as of 2023, what their understanding of potential implications under the laws that the FTC enforces of improper Orange Book listings. But is this the first time we're seeing the FTC weigh in on issues related to the Orange Book, or does this represent a shift in how the FTC is viewing these issues?
It's definitely not the first time the FTC has weighed in on Orange Book listings. And in fact, in that policy statement from September 2023, the FTC referenced several other actions that it has taken in this area, going back over 20 years. Back in 2002, the FTC examined the potential anti-competitive effect of improper Orange Book listings as part of a study in which it identified numerous instances in which the 30-month stay was used to block competition. In that policy statement, the FTC also cited a case that it had brought also in 2002, where the FTC issued a complaint and entered into a consent order with BioVail Corporation for unlawfully acquiring a patent from a third party and wrongfully listing that patent in the Orange Book to block generic entry. Under the terms of that consent order with BioVail, the FTC ordered BioVail to divest part of the exclusive rights of the patent that it had acquired back to the licensor. It was also prohibited from taking any action that would trigger additional statutory stays on final FDA approval of the generic form of its drug. And it was also prohibited from wrongfully listing any patents in the Orange Book for any product that it had an FDA-approved new drug application. In addition to the BioVail enforcement action in 2002, the FTC has also been active in filing amicus briefs in private litigations concerning Orange Book issues over the years. 3 of the amicus briefs that the FTC cited in its policy statement were from the early 2000s. But more recently, in November of 2022, the FTC issued or submitted an amicus brief in a case called Jazz Pharmaceuticals v. Avadel CNS Pharmaceuticals. That case, I think, is worth a quick discussion since it's a more recent illustration of the kinds of cases that the FTC is weighing in on. Jazz Pharmaceuticals has an approved drug called Xyrem, which is used to treat narcolepsy. Xyrem is a controlled substance, and it's subject to what's called a risk evaluation and mitigation strategy, or REMS. And a REMS is a set of FDA-mandated requirements to mitigate safety risks and minimize potential for misuse or abuse of controlled substances. And in this particular case, the REMS for Jazz's drug imposed strict rules on how the company or how the drug could be distributed to patients to ensure that the drug was dispensed to patients with a valid prescription. Jazz's REMS, in particular, require the distribution of Xyrem through a single pharmacy system. Now, Jazz had a patent relating to its single pharmacy distribution system, which, according to Jazz, covered methods of using a system to safely distribute Xyrem to treat patients with narcolepsy. Jazz listed that patent in the Orange Book as a method of use patent for Xyrem. And so the case boiled down to whether the REMS distribution system covered by Jazz's patent was a method of using Xyrem, and thus whether Jazz's Orange Book listing was proper. The FTC weighed in with an amicus brief to argue that Jazz's patent merely claimed a method of distributing the drug rather than a method of using the drug. And so according to the FTC, because the distribution patent had nothing to do with the actual drug or a method of using the drug, it should have been delisted from the Orange Book.
Just a quick follow-up on that. We talked about these actions taken in 2002 and then a 2-decade-long gap before we start seeing more amicus briefs and this policy statement. Is there anything to take from that delay?
Yeah, it's certainly, if you were to graph this out on a chart, you definitely see a huge bump in 2000 and thereabouts, and then it comes back down for a while and the issue lays dormant, and then you see this resurgence more recently and after 2020 or so. And I think this is just my personal opinion. I haven't done a deep dive study on this, but I think this may be a sign of the current administration in an attempt to revisit these laws and understanding how to enforce Section 5 of the FTC Act in particular. I think the current antitrust administration at the FTC is really taking a new look at all of the antitrust laws, and in particular, its enforcement authority under Section 5, to make sure that these laws are being properly enforced and they're ensuring vigorous competition in all areas of the economy. To me, it seems consistent with what we've been seeing overall in the past couple of years of antitrust enforcement from the FTC.
Since these amicus briefs and the policy statement, have there been any other indications that the FTC intends to continue doing more in this area? And have they suggested where their focus areas will be, either in terms of types of drugs or looking at, particular sectors or manufacturers?
Yeah, so in November of 2023, just less than 2 months after issuing that policy statement, the FTC sent notice letters to 10 pharmaceutical companies, and as well as patent listing dispute notifications to the FDA that identified specific patents that the FTC believes have been improperly or inaccurately listed. And for the most part, the patents at issue appear to cover medical devices like asthma or other inhaler devices. They also cover epinephrine autoinjectors, commonly known as EpiPens. And since those 10 letters were issued, at least 3 companies have withdrawn certain patents from the Orange Book. Now, the FTC didn't provide a ton of guidance on exactly why it believed those patents were improperly listed. The letters to the 10 companies were made public, but they were pretty light on details other than listing the specific patents that they believed were improperly listed. But shortly after the FTC issued those 10 letters, Rahul Rao, who is the deputy director of FTC's Bureau of Competition, gave an interview that shed a little bit more light on where the FTC is going with this. And when asked how the FTC came to choose the patents that were cited in the letters, Mr. Rao said that the Orange Book is only supposed to list patents covering active drug ingredients. And so the FTC focused on device patents that have nothing to do with the active drug. The deputy director also noted that we would like the FTC, with the companies to delist the patents, and that the FTC hopes that enforcement won't be necessary because they hope that the companies will simply comply with their view of the law and remove those listings. A couple of weeks after issuing those letters to the 10 companies, also at the end of November 2023, the FTC filed another amicus brief in a private litigation between Sanofi and Mylan involving Orange Book listed patents. These were patents that related to Sanofi's insulin injector pen device. In that case, Mylan argued that some of Sanofi's patents were improperly listed because they only related to the injector pens, but they didn't claim the actual insulin drug product. Now, the FTC didn't take as strong of a position about the propriety of Sanofi's patents as it did in the Jazz v. Avidel case. But it simply wrote in to say that if Sanofi improperly listed its patents in the Orange Book, then they may have caused harm to competition and may therefore violate the antitrust laws. So November of 2023 was a busy month for the FTC with Orange Book listings, and they certainly seem to be focused on medical device patents.
Right. So you, in your practice, are, of course, a lawyer who works at a drug manufacturer in the industry. And with the FTC coming out and saying that they're prepared to issue additional letters and scrutinize more Orange Book listings, what kind of unanswered questions do you see out there? And do these actions by the FTC create any uncertainties for drug manufacturers?
It certainly seems that there's certainly a suggestion that this is just the first wave of letters from the FTC. In the interview that Rahul Rao gave, he suggested that there may be more to come. And so the question I have is, if there are more letters or actions to come, what patents in particular is the FTC worried about? The 10 letters that we saw in November seem to be focused on medical devices. I think the FTC wants to paint this as a very black and white situation in that they're talking about device patents, whereas the Orange Book is only talking about drug patents or methods of using drugs. So I haven't studied any of these patents in detail that the FTC is challenging, so I have no opinion on whether those patents were appropriately listed. But one issue that I do see percolating is that when you're looking at drug device combination products like EpiPens or inhalers, that question of whether it's a drug or a device is going to get a little bit more complicated. And particularly as medical technology advances, I think that line between drugs and devices is becoming even more blurred. If you look at like oncology and other therapeutic areas, you really have these fascinating, new, innovative treatments that really combine what we used to consider a device with the pharmaceutical product itself. You have devices that are inserted into patients' bodies that elute the medication to make the medicine more targeted or effective. You have metal beads being put into people's bodies to where they can direct radiation more specifically to the area that needs to be radiated, but keeping it out of other areas that don't need that toxicity. And as we see more advancements in medicine, I think that line, that distinction between drugs and devices may become harder to draw. It's also unclear to me what the FTC is going to do if the parties don't comply with these letters. These letters themselves don't really have the force of law. And as Deputy Director Rahul Rao said, they hope that these companies delist, and they're really relying on the FDA process. But what happens if they don't? And if the FDA doesn't delist the patents themselves, I think the question is, will the FTC actually go further and bring an enforcement action? They're certainly indicating that they're thinking about it. But again, the last enforcement action that we saw in this space was in 2002 involving BioVail Corporation. And I think the facts of that case were really unique and probably worth highlighting here because in my reading of that case, it wasn't really about whether the patents fit the requirements of the Orange Book listing. It was instead about the facts and circumstances that surrounded that Orange Book listing. BioVail manufactured this branded drug called Tyazak, which is used to treat high blood pressure and chronic chest pain. And Andrix was a company that was seeking to get a generic version of Tyazak approved. And so the parties went through the Hatch-Waxman song and dance. BioVail listed its patents in the Orange Book. Andrix filed a paragraph 4 certification, and then BioVail sued Andrix for patent infringement and triggered that 30-month stay of FDA approval. And while those parties were litigating the patent suit, the FDA tentatively approved Andrix's drug application and said that the generic would be approved after expiration of the 30-month stay. So that's all pretty typical Hatch-Waxman process. Here's where it got a little interesting. Before that 30-month stay expired, so before Andrix could enter with its generic, BioVail then listed a second patent in the Orange Book for Tyazak. Now, BioVail had acquired that patent through an exclusive license with another drug company. And as a result of the new patent listing, the parties went through a second round of the Hatch-Waxman process. Andrix filed another paragraph 4 certification, and BioVail again sued Andrix and triggered that 30-month stay. So the FDA's concern in that case was that BioVail's exclusive license to the new patent was an unlawful asset acquisition under Section 7 of the Clayton Act, and that BioVail unlawfully maintained its monopoly on Tyazak by wrongfully listing the newly acquired patent in the Orange Book for the purpose of blocking competition with Tyazak. There was also an interesting side story in that case where Andrix petitioned the FDA to delist BioVail's newly acquired patent. And in that process, the FDA asked BioVail for confirmation that the patent was properly listed. BioVail submitted a declaration to the FDA confirming that the patent was properly listed because it related to the drug Tyvaso. The FTC, in its enforcement action, alleged that BioVail's declaration was misleading because it wasn't clear whether Tyvaso in that declaration meant the FDA-approved Tyvaso or a revised, unapproved version of the product. There were certainly elements of that case in 2002 that I wouldn't call it bad faith, but maybe an ulterior motive behind some of the actions that I think were particularly unique to that case. You have the fact that BioVail triggered not one, but two 30-month stays. There was this kind of questionable acquisition of the patent license, which is what enabled BioVail to trigger that 30-month stay, the second 30-month stay. And then there's this potentially misleading declaration to the FDA. So for me, I think the BioVail case suggests that the FTC may, if it were to consider bringing an enforcement action, they may be looking for some unique plus factors before it actually brings a case involving Orange Book listings.
Thanks, Mika. That's super helpful. And I think getting your holistic view of where the FTC started with this and where we are now is super helpful to piece together these various aspects of where the FTC has gone. And the points you made at the end are really illuminating because I think we have heard news reports that some of the companies who received letters do stand by the listing of their patents. That kind of plus factor, bad faith, good faith aspect of it might come out soon, and we'll see where this is headed. So before we let you go, we know you knew fun facts about the color of the Orange Book and Halloween, which I never knew by dealing with the Orange Book for a decade. So thank you. I'll pass that along for sure. So let's have you tell us something about yourself other than knowing fun facts about the Orange Book that we wouldn't know if we only knew you professionally.
I think by now that I love fun facts. And if you take nothing from this podcast, it's that I want you to know why the Orange Book was orange. So here's a fun fact about me. I never wanted to be a lawyer. I grew up wanting to be a pianist. To the point where I wasn't even sure if I wanted to go to college. I thought long and hard about maybe going to conservatory. And so it's funny that I stumbled into this profession. But I love it. It was a happy accident. But if there's anybody out there in the Antitrust bar who plays classical, is a classical musician, I would love to meet you and maybe form a chamber music group.
That sounds great. Jeny and I will attend.
Yes.
I've got some practicing to do, though. It's been a while.
It never ceases to amaze me how musical the Antitrust bar is.
And now let's go to our final segment.
And now it's time for the Curious Hat.
So this is called the Curious Hat. What was the last movie you saw, and what did you think of it?
Oh, the first part is easy. Just a week ago, I saw the new Wonka movie, the Willy Wonka movie with Timothée Chalamet. This may be blasphemous, but I was not impressed. I was underwhelmed. I thought it wasn't great. The music was not very original, and yeah. But I don't want to end it on a bad note. I wish you had asked me what the penultimate movie I had seen was, because that was the Taylor Swift Eras Tour movie, and I actually wasn't expecting much from it, but you know what? Now I get it. I totally get it. I get why she's Person of the Year. It was fantastic. I might even buy a ticket to go see her in person.
Well, now you are a lawyer, a pianist, and a Swiftie. So.
Yes, the hat trick.
Thank you so much. And to our listeners, thanks for listening in, and we'll see you next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.